true justice begins where mercy meets law. That quote, which comes directly from the sources we're analyzing today, really it sets the stage perfectly for this deep dive.
It really does.
We are looking at a specific set of historical legal precedents. I mean, these are rulings that predate so many of the foundations of what we think of as modern human rights law.
By centuries.
By centuries, exactly. And yet, they define justice not primarily as, retribution or punishment,
Right.
but as the absolute protection of human dignity. And that protection extends unequivocally even to the accused. Welcome to the Deep Dive. I'm your host, and I am genuinely excited to unpack the complex and I think often pretty radical legal philosophy contained in this material.
And I'm here to help connect these foundational principles,
Yeah.
these constitutional decisions, if you will, to the broader picture of legal and ethical governance. We'll be looking at how these concepts developed and, more importantly, why they're still so relevant today.
And for you listening, just to set the scene, we're focusing on a very specific block of material.
Yeah, we're looking at excerpts concerning cases 111 through 120 from the scholarly text, Prophetic Justice, Rights of the Accused and Human Dignity.
This analysis feels like the next logical step, doesn't it? It follows our previous deep dive on judicial independence.
Exactly. It's the perfect follow-up.
Because if judges are independent, the natural question is, okay, what essential safeguards are there to protect the individual, to protect them from the power of that judiciary, or even just from a false accusation?
That's the core question. And
All right.
our source material frames these cases as mandatory guidelines. They're not suggestions. They are rules that dictate how an investigation, an interrogation, a trial, and even punishment must occur.
So these rulings establish the rights of the accused as what? Non-negotiable.
Completely non-negotiable, centering on the sanctity of the human being.
So our mission today is to extract exactly how these historical principles establish safeguards that, almost prefigure core concepts in modern criminal and human rights law. We want to give you, the listener, a really thorough understanding.
The kind of shortcut.
Yeah, a shortcut to knowing the foundational ethical structures that underpin the entire justice system described in these sources.
Okay, let's unpack this. We're going to start at the absolute beginning of any legal process. And this is perhaps the most important single principle in all of criminal law.
I would agree with that.
It's Case 111, Presumption of Innocence. This is the starting line of justice itself. And the court principle is, well, it's uncompromising. Every single person is innocent until proven guilty.
And to really appreciate how radical this ruling was, we have to look at the historical context. I mean, in so many ancient and medieval systems, especially systems where, resources for a proper investigation were scarce.
Right, they didn't have forensics labs.
Exactly. The accused often bore a really heavy burden to prove their own innocence. This was especially true if they lacked status or wealth. So establishing innocence until proven guilty as this absolute baseline rule, it just fundamentally shifts the entire power dynamic. And the source material really drives this home. It enshrines that incredibly powerful legal maxim. The burden of proof is on the claimant.
That maxim is everything. It really is. It means that the entire machine of the state, all of its power, cannot move against an individual based on, say, mere suspicion or hearsay.
So just because someone thinks you did something?
Right. If the burden is on the accuser, the claimant, it means the accused doesn't have to disprove anything. They don't have to defend themselves against rumors or a bad reputation. The prosecution, whether that's the state or a private person, must actively investigate, gather clear evidence, and then present a compelling factual case that removes all reasonable doubt.
That imposes an immense amount of structural discipline on the government, doesn't it? It prevents what we would now call, fishing expeditions.
Or preventative detention just based on a hunch.
Right. But let me ask you this. Practically speaking, how did the early courts balance this very high burden of proof with the societal need for order and security? I mean, didn't this make catching criminals significantly harder?
It absolutely did impose a constraint, but that constraint was seen as a deliberate feature, not a bug in the system.
So it was intentional.
Completely. The philosophical choice embedded in this principle is explicit. If you're forced to choose between punitive efficiency, catching people quickly, and the risk of punishing an innocent person, the system must always choose to protect the innocent.
Wow.
So this mandate, it forces the authorities to prioritize rigor and verifiable evidence. The governance model basically accepts a degree of inefficiency for the sake of ethical integrity.
So it anchors the entire justice system in trust, not in suspicion.
Precisely.
And the success of the system is measured by how many innocent people it protects, not just by how many guilty people it convicts. That legal DNA is why, centuries later, the presumption of innocence became the indispensable core of modern criminal jurisprudence worldwide.
It is. It's the ethical floor. It's the foundation upon which all fair legal systems must stand.
So, if innocence is the default internal state of the accused, as we see in Case 111, the next logical question is what external boundaries protect that innocent state?
Good way to put it.
And that brings us directly to Case 114, privacy and protection from unlawful search.
And the core principle established here is the strict prohibition of intrusion into private life. This covers the home, private affairs, correspondence. Everything. Unless a specific, grave, and lawful cause is proven. The private sphere is defined as inviolable, sacred even.
The source material provides a very specific and, I think, actionable defense of this right. It talks about the defense of the home against unwarranted intrusion. The saying attributed here is profound, it says. If someone peeps into your house without permission, you may resist him. And what's just remarkable to me is the implication there. The right to privacy isn't just a passive thing. It's not just a constraint on the government's behavior.
No, it's active.
It's an active fundamental right. It's an actionable defense of one's sacred space. It empowers the individual to physically defend their boundary against an unwarranted invasion. It's treating the intrusion itself as a violation that justifies immediate resistance, almost like a physical assault.
It is. The sources emphasize that the home isn't just property. It's not just a collection of walls. It's a sanctuary, a place of personal repose and security. And allowing authorities or even nosy neighbors to easily violate that space, well, it undermines the very security and peace the system is meant to provide in the first place.
So this ruling draws a hard, clear line.
A very hard line. It teaches both the police and the public that the home is indeed a castle.
But again, this presents a real tension for early governance. I mean, if you establish the home as this fortress, how do you conduct effective criminal investigations? You know, when a serious crime, say theft or harboring a fugitive, is suspected inside, how did the law manage that necessary requirement for evidence gathering with this absolute right to privacy?
That tension, it forced the development of very strict procedural safeguards. Things we would recognize today as, like, requirements for obtaining warrants.
Yeah.
The authorities couldn't just rely on general warrants or, vague suspicions. The sources indicate that specific, verifiable information indicating criminal activity within that private space was necessary before permission for entry could be granted.
So you had to have something solid.
Something very solid. In effect, the presumption of innocence from Case 111 had to be overcome even to breach the threshold of the home. The bar for entry had to be demonstrably higher than the bar for, say, an arrest out on the street.
It requires the state to prove the need for intrusion before the intrusion happens.
Yes.
Rather than invading and then trying to find proof.
Oh.
This principle directly mirrors constitutional rights, centuries later, regarding protection against unlawful search and seizure in modern law. It's uncanny.
It is.
Okay, so we've established the initial position of innocence and the sanctity of the private sphere. Now we have to move into the mechanics of the investigation itself.
Right. What happens after an arrest?
Exactly, and that starts with Case 112. Prohibition of torture and coerced confessions. And this is a non-negotiable boundary for any system that claims to have any moral authority.
It is the defining line. The principle is the strict prohibition against any physical or psychological coercion used to extract a confession. The system must operate on truth derived from verifiable evidence, not truth manufactured by pain or fear.
The source provides a really vivid and strong admonition. It was given when an officer stepped over that line and punished a suspect harshly. The prophetee didn't just issue a reprimand or, a warning. He explicitly stated a profound consequence. He said, God will punish those who torture people in this world.
And that right there introduces a level of consequence far beyond, say, an administrative review or suspension.
Oh, absolutely. Torture becomes a moral and a theological transgression of the highest order. It invokes divine punishment against the state agent who does it.
That is the crucial insight here. It elevates the prohibition from a simple procedural rule to an existential moral mandate. Torture isn't just seen as, bad police work. It's an act that endangers the very soul of the perpetrator. And on top of that, the legal consequence is just as robust. A confession obtained under duress is automatically completely invalid in Islam.
Wait, let's just pause on that for a second. The legal consequence. If the confession is invalid, it means the state gained nothing by engaging in the abuse.
Zero. It's inadmissible. Useless.
That double sanction, the legal invalidation plus the theological consequence, that is an incredibly robust deterrent.
Absolutely. The system is designed to remove the incentive for cruelty.
Right.
I mean, why would you use violence if the evidence derived from that violence is completely useless in court?
It's self-defeating.
It is. By rendering the coerced confession moot, the law protects itself from the contamination of immorality, and this early, explicit prohibition. It's a direct parallel to Article 5 of the UN Declaration of Human Rights Freedom from Torture, which remains a fundamental tenet of humanitarian law today. It just showcases an astonishingly early commitment to humane treatment during detention.
So if we can't force a confession through coercion, that leads us logically to the next step, which is Case 113, right to silence and fair defense. What expectation did the courts have that the accused must speak to, clear their name?
The core principle here is, again, highly modern. Silence was not treated as an admission of guilt.
So staying quiet doesn't make you look guilty.
Not in the eyes of the law, no. The accused maintained the full right to defend themselves or, critically, to remain silent without any prejudice against them.
The source mentions its application across various situations, right? Including cases involving, I think, property disputes and slander.
Yes, and in those cases, the prophet key never compelled the accused to speak against their will. They had the right to speak, but absolutely no obligation to do so.
What's fascinating here is how this concept acts as a complete shield. You mentioned this before. It preempts the concept of self-incrimination.
It does. It's the very same logic. If the accused is silent, the prosecution must still meet that high burden of proof we talked about in Case 111.
The burden doesn't shift.
It never shifts. The accused does not have to provide the rope for their own hanging, so to speak. This safeguard prevents the state from building a case solely through a forced admission, ensuring that the trial focuses on external, verifiable evidence.
So the state can't just wear down the accused in an interrogation until they confess out of sheer exhaustion or intimidation.
Exactly.
The prosecution has to actually do the hard work of investigation, of evidence gathering and presentation, and do it all independent of whether the accused cooperates or not.
It preserves the integrity of the process. It ensures the trial is genuinely adversarial, requiring the state to meet a rigorous, objective burden of proof.
It maintains the balance of power.
That's a perfect way to put it. While the state possesses these immense resources, investigators, judges, courts, the right to silence gives the accused a crucial defensive tool. It acknowledges the inherent vulnerability of the individual when they're faced with the full power of state authority.
Now let's turn our attention to the social dimension of justice. I find this part incredibly compelling. It's tackled in Case 117, equal treatment of the poor and the powerful. This addresses the pervasive and, I think, destructive issue of selective justice.
And the core principle here is, again, just uncompromising. Social status, lineage, wealth, or power could not and should not influence legal procedures or outcomes. Justice must be administered blindly, applied universally to all citizens, regardless of their standing in society.
And the source material here delivers a historical warning of astonishing clarity. It links judicial failure directly to civilizational collapse. It's not a small warning.
Not at all.
Discussing selective justice, the prophet warned, "Nations before you were destroyed because they punished the weak and spared the strong."
A powerful statement.
It is so much more than just a moral ideal. It's a structural diagnosis of societal failure. The takeaway is that discrimination based on class or power isn't just unfair. It is inherently corrupting and destructive to the legal fabric itself. So my question is, why did the sources emphasize that selective justice leads to destruction, not just, public dissatisfaction?
Because it speaks directly to the legitimacy of the state. When justice becomes transactional, when it bows to wealth or influence, the general public loses complete faith in the moral order.
The system loses its authority.
It loses all moral authority. And once that public trust is lost, the law becomes nothing more than a tool of oppression wielded by the elite. The resulting breakdown of social cohesion and moral authority means the entire structure, regardless of its military or its economic strength, will inevitably collapse from the inside out.
So this ruling makes universal equality under the law a survival mechanism for the civilization.
Exactly.
Yes.
It's not just a nice idea. It's a matter of survival.
It means that upholding the rights of the poorest, most vulnerable citizen is actually an act of self-preservation for the most powerful state. And this remains a global constitutional ideal today. When we see nations struggle with corruption or internal division, it's often a failure to uphold this very old, very fundamental principle that the strong and the weak must face the law equally.
It's a timeless lesson.
So we've established the rights of the accused from the moment of suspicion all the way through interrogation. Now we move to the mechanics of the decision itself, focusing on Case 118. No punishment without due process. How did the sources define the necessary steps for a judgment to even be considered valid?
Well, the core principle is incredibly robust. Punishment was never, ever imposed arbitrarily. A full investigation and a complete, fair hearing were mandatory preconditions for any legal consequence. Due process wasn't, an optional checklist.
Right.
It was the very mechanism that validated the law itself. Without it, a ruling was just an opinion.
What's unique here, though, is the standard set for the judge's state of mind. The specific instruction given was, a judge must not decide while angry, nor punish without full clarity. Here's where it gets really interesting, because we are talking about two deeply intertwined requirements for due process. It's not just one thing.
No, it's two-pronged.
First, there's the objective requirement of full clarity. The facts must be completely, exhaustively understood and verified. But second, there's the subjective requirement of emotional neutrality. The judge's own temperament is explicitly made a mandatory component of due process.
That is the deep insight, and it's a remarkably sophisticated legal concept for its era. Procedural soundness requires both factual integrity and emotional integrity. If the judge is compromised by anger or haste or fatigue or some personal bias,
anything
at all, the procedure itself is deemed flawed and the judgment invalid, regardless of what the potential factual outcome might have been.
So let me get this straight. If a judge rushes a case because they are frustrated or makes a ruling while they are emotionally compromised, the accused could potentially challenge the verdict not on the facts of the case, but on the judge's temperament.
That's exactly it.
But what mechanism existed to monitor or enforce that? I mean, that's an internal emotional state. How do you prove a judge was angry?
Well, you couldn't necessarily measure internal anger with, a physical gauge, but the requirement imposed a very strict standard of behavior and deliberation. Judges were expected, even required, to postpone cases if they felt compromised, whether they were sick or tired or angry.
So the onus was on the judge themselves.
It was. But the enforcement also came from the appellate process if the judgment was appealed, and from public scrutiny. A judgment that was delivered with obvious haste or evident emotion would immediately raise questions about whether that full clarity standard had really been met. It elevates the standard of judicial behavior from mere competence to really ethical and emotional mastery.
It acknowledges that human emotion is a variable that the law has to control for. It sets an extremely high bar, ensuring that justice is dispensed deliberately, logically, and calmly. It has to reflect the seriousness of the decision, rather than being reactive or impulsive.
And this two-pronged requirement, it became a cornerstone of both administrative and criminal law in this tradition, ensuring that decisions are sound in both procedure and in spirit.
We're going to transition now from the procedural safeguards, the how of the court, to the ethical goals, which is really the why of the system.
The purpose behind it all.
Yes. Justice is so often seen as just retribution, but these sources seem to emphasize restoration, starting with Case 116, opportunity for repentance and reform.
And the core principle here, it completely shifts the system's focus. It says that encouraging self-accountability and reform before judicial punishment is paramount. The goal is to guide the individual back to the moral path, not simply to hunt them down and punish them.
This principle is so powerfully illustrated by that famous anecdote found in the sources, the case of Maez.
Yes, a very famous case.
He approached the prophet and confessed to a very grave sin, adultery. But the prophet, he turned away from him multiple times. He gave him repeated intentional chances to withdraw his confession. He was essentially urging him toward private repentance rather than a public penalty.
This is one of the most structurally revealing moments in the entire source material. The prophet was not seeking a conviction. He was actively creating an off-ramp, a judicial preference for mercy. By turning away, he established a legal precedent that says, the highest good is private correction and repentance. The law must guide, not hunt.
Why is actively discouraging a confession a key legal principle? It seems so counterintuitive to a state's goal of swift, orderly justice.
Because it underscores that the purpose of the justice system is not merely to enact state power or to satisfy some need for revenge. The ultimate purpose is the rectification of the individual.
The healing of the person.
The healing of the person, and by extension, society. If an individual can rectify themselves through sincere repentance and avoid public sanction, that outcome is considered superior. Reform is explicitly stated as being nobler than revenge. It protects the dignity of the confessor, and it avoids the social trauma of a public punishment.
That ethical framework, it directly informs modern approaches like probation and rehabilitation systems. It values the potential for change, the dignity of the future person over just crushing retribution for a past action. The system is designed as a tool for societal healing.
It creates a crucial buffer. The state holds the sword of justice, but it seeks to use the shepherd's crook of guidance first.
That ethical framework sets a necessary tone for the next case, Case 115, avoidance of public humiliation. So once guilt is established and a punishment is rendered, what happens next? What's the follow-up?
The core principle here is the strict prohibition against shaming, ostracizing, or insulting the offender, even after their guilt was established and the punishment was carried out. The idea is that the debt is settled when the sentence is fulfilled.
And the specific detail here, which was given after a punishment was carried out, is incredibly powerful. The command was, do not insult him, for he has purified himself through this.
Such a powerful phrase.
That phrase, he has purified himself, that's the key, isn't it? It reframes the entire purpose of the penalty. It means punishment is a mechanism of restoration, not a brand of permanent stigma.
Exactly. Once the prescribed penalty has been paid, the social debt is settled, and the person is to be reintegrated, free from the lingering shadow of public shame or gossip.
This directly addresses that societal temptation towards permanent shaming, which is so common.
It is. The sources teach that public shaming works directly against the goal of purification and societal reintegration. If you shame someone forever, you ensure they can never fully return to contributing to society. You're creating a perpetual class of outcasts.
And this forms a foundational ethical principle for what we now call restorative justice. When the sentence is complete, the community's obligation is to accept the purified individual back without stigma. This stands in stark contrast to many modern legal systems that include, lifetime registration requirements or public registries that perpetuate shaming long after the debt to society has supposedly been paid. This ancient system was seeking completeness and closure.
It's an insistence that every human being retains their fundamental dignity, regardless of their past errors.
Moving forward from that, we have Case 119, forgiveness as a legal option. How does forgiveness transition from just being a moral virtue to becoming a structural preference within a structured legal system?
Well, it's clearly elevated to a preferred option. This is especially true concerning personal grievances, where the victim has the legal right to claim compensation or seek retribution. The core principle is that forgiveness and reconciliation were actively preferred over purely punitive outcomes.
And the encouragement to victims was explicit.
Very explicit. Forgive, for forgiveness elevates your rank. And you have to understand, this isn't merely a religious recommendation. It's an incentive that's structured into the ethical guidelines of the judicial system itself. It suggests that a superior judgment, one that heals both the victim and the offender, is achieved through pardon. The court itself would often urge reconciliation whenever possible.
This profoundly transforms the victim's role in the process. They transition from just being a passive recipient of state justice into an active participant who can actually determine the outcome.
It empowers them.
It empowers them to choose healing over simple retribution. And that often involves negotiation, restitution, and ultimately a pardon.
Exactly. Forgiveness is not just a moral virtue, but a legal and moral option that provides a superior outcome, a judgment that heals, not one that harms. It creates a space for reconciliation that purely punitive systems often just obliterate because they focus entirely on the state versus the offender.
And they forget the relationship between the victim and the offender.
They completely forget that relationship. This is the very spirit that underpins current restorative and reconciliatory justice frameworks all over the globe.
Finally, we arrive at the culminating principle, the one that sort of ties all of this together. Case 120, human dignity above all. This acts as the moral ceiling for the entire legal system we've just reviewed.
It does. The core principle is the declaration that human dignity is inviolable. It is the central, non-negotiable standard that remains throughout the entire process, from the first moment of suspicion even into the necessary act of punishment.
The overarching mandate is so encompassing. It requires total adherence to fairness. It says, indeed, Allah has prescribed excellence in everything. If you punish, do so with fairness.
And if we connect this to the bigger picture, this single principle synthesizes the spirit of all 10 cases we've discussed. The requirement of excellence in everything sets the ethical benchmark for every single step.
So investigation must be excellent.
Due process must be excellent. Even the punishment itself must be excellent, meaning it has to be administered without cruelty, without bias, and without any needless humiliation.
This dictates that justice without compassion, or justice that strips the accused of their inherent human worth, it automatically fails the test of excellence and becomes tyranny.
It does. It's an instruction for continuous conscientious governance.
This principle is really what defines humanitarian law and ethical governance. It takes the legal process and frames it within a system that honors the inherent worth of the individual, regardless of their position or even their guilt. It ensures the state never sacrifices the individual's humanity, even when it's exercising its legitimate right to punish.
Perfectly said.
So what does this all mean? We've just completed a pretty intensive deep dive into 10 cases, 111 through 120, that establish the foundational rights of the accused. And it's clear these aren't just, historical curiosities.
Not at all. They are a sophisticated system of checks and balances designed to prevent the abuse of state power.
Let's reinforce the list of core principles that we've extracted from this source material, just to demonstrate how comprehensive these safeguards really are.
Good idea. So 1, presumption of innocence until the burden of proof is met. 2, an absolute prohibition of coercion and torture.
3, the right to silence, which is never treated as an admission of guilt.
4, privacy is a sacred, actionable right protecting the home. 5, public humiliation of the offender is strictly forbidden after they have been purified through their sentence.
6, reform and repentance are preferred over immediate revenge. 7, absolute equality of treatment regardless of a person's status or power.
8, due process, which requires a full factual investigation and, crucially, judicial neutrality and emotional detachment. 9, forgiveness is a preferred legal option for reconciliation and healing.
And 10, human dignity is the inviolable standard for the entire system, requiring excellence in every single application of justice.
These principles show that the Prophet set transformed justice from what could be a cold, technical process into a moral art. It's rooted profoundly in mercy, in reason, and in an unwavering respect for human dignity.
It's a system designed to protect the weakest link, the accused, and by doing so, it strengthens the entire society.
And I think the most profound aspect is that these safeguards were not reactive measures. They weren't adopted after centuries of abuse. They were foundational principles established at the very genesis of the legal framework. They are the rule, not the exception.
We have so much more to cover in the source material we are working through. We are moving beyond the individual's rights in the courtroom and into their rights in the marketplace.
That's right. In our next deep dive, we'll explore cases 121 through 130. We'll be shifting focus dramatically to economic rights, labor justice, and protection of the poor. We're going to analyze how these historical decisions created an economy of fairness and compassion long before any modern welfare state existed.
We look forward to having you join us for that fascinating discussion.
But for now, we'll leave you with this powerful image, which is provided by our source material, for you to ponder the lasting impact of this comprehensive legal philosophy.
In the Prophet's court, justice was not a sword. It was a mirror that reflected mercy, equality, and the dignity of every soul. That is the justice the world still seeks today.